One of the most common questions that we get as estate planning attorneys is, what's the difference between a will and a trust, and do I need a trust or do I need a will? And it really depends on each client's particular circumstances and situation and what they're trying to achieve. So fortunately for estate planning attorneys, we have lots of tools in our tool belt that we can use to create an estate plan for a client. Some tools are better than other tools, but there's no one magic way to do anything. There's lots of different ways that we can do things. I would say in 20 years of practicing law, when people come in, they say, do I want a will or do I want a trust, and what's the difference? At the end of the day, usually, most of the time, it's going to be a trust. It's going to be the superior document. And so what I want to do is just kind of diagram for you why that is the case. In most cases, I'm not saying every time, every situation, a trust is going to be the right vehicle to use, but most of the time, the trust is going to be the best vehicle for most clients. And this is why. The primary objective of most clients when they come in, when we ask them, what are you trying to do with your estate? What's our primary goal? What's our primary objective? With these assets that you worked your whole life to earn and obtain, what is our primary goal? Well, number one, I want things to be as efficient and as easy as possible when I pass away. Or should I become incapacitated, I want my loved ones to have access to these assets, to be able to write checks and pay bills and have access to my accounts and do what they need to do upon incapacity or upon death. And so when we ask, well, do we want to go through probate? Do we want to avoid probate? Do we have a probate issue? What's the value of our estate? How are our assets titled? Do we have beneficiary designations on assets? When they answer those questions, typically their primary objective is to stay out of probate. When we ask those questions, they say, yes, I don't want to be in probate. And there's two types of probates that we have to be familiar with. The first is living probate, and the second is death probate. And so how a will deals with these issues. If our assets are just in our name and our assets exceed a certain dollar amount, these dollar amounts have increased recently in Arizona. They've gone up to $200,000 for everything except real estate and $300,000 for real estate. If we're over those threshold amounts and the assets are just in our name with no beneficiary designation on them, then we have a probate problem. And so if we're alive and we own something and we become too incapacitated to manage that thing, and the thing is just in our name, it's not jointly owned, then we have to go to court, probate court, living probate, to get someone to be appointed to manage those things for us if we have a will. And when we die, if we have a will and the assets are just in our name, no joint ownership, no beneficiary designation, and they're over those probate threshold amounts I just said, then we have to go through death probate. So potentially, if I become incapacitated before I die, and then I pass away, my loved ones could end up going through two probates, one while I was alive and one when I die. Well, what's the problem with probate? Why do we try to avoid probate? Well, probate means court, and court means attorney's fees and court costs and time and delay, and the court is in control, and the publicity of court and the stress that goes with court and all the stuff that goes with being in court. So most of our clients, they say, when we say, what are your objectives with your estate? Most clients say, well, I don't want to be in this mess. I don't want my loved ones to be in this mess. But if that's the case, then we don't want to utilize, typically, a will for estate planning, because a will won't solve these two issues. A will does nothing for us while we're alive if we become incapacitated. A will only comes into effect when we die. And if we have a will when we die, and our assets are over the probate threshold amount, they're not jointly owned, and there's no beneficiary designation, then a will force us into probate when we die. So, how do we solve those problems? How do we solve a living probate problem and a death probate problem? Well, the trust does that. The trust solves these two issues, in addition to doing lots of other really neat, cool things that a trust can do that a will won't do for us. And so most of the time, a trust is going to make sense. The type of trust is a revocable living trust. Clients can change it, alter, amend it, or revoke it. How it does it? How does a trust work? Well, the trust owns the assets. The assets are not owned by us as people. And why do we not want people to own things? Well, because people get sick. They become incapacitated. A little scribbly line across the forehead means incapacitated. That forces us into living probate. And people tend to die. And that forces us into death probate. So we don't want people typically owning things. We want this thing called a trust to own our assets. Now, if we become incapacitated or die, there's no probate because we don't own the asset. The trust does. The trust doesn't get sick. The trust doesn't go on vacations. The trust doesn't die like people. And that's what helps us stay out of probate. So there's lots of other really cool things that a trust can do in addition to staying out of probate, like protecting the assets for our loved ones from divorces and creditors and bankruptcies and taxes, and lots of really cool things that a trust can do in addition to appointed probate. But this is the primary reason why most people would pick a trust over a will. Hope that helps.